All right, the next matter to come before the court is Colopy versus Children's Hospital Medical Center. Each side will have 15 minutes to present its arguments. Appellant can reserve up to 5 minutes for rebuttal if you wish to do so. Whatever time you want to reserve, let me know when you take the podium. Our screen's not working. I'll do my best to keep you apprised of your time.
Okay.
I don't think I need to warn you about children or victims' names here. Keep your voice up and stay behind the podium. The arguments are being visually and audibly recorded.
Okay.
Whenever you're ready.
May it please the court, counsel. My name is Dean Hoover. I'm here on behalf of Tara Colopy, both in her individual capacity and in her representative capacity of the putative class in this class action.
Rebuttal time.
Oh, I'm sorry, 5 minutes.
Okay.
This one, thank you.
Sure.
The reason the law bothers to segregate counterclaims into compulsory counterclaims and permissive counterclaims is that with regard to compulsory counterclaims, res judicata sometimes applies. The concepts are intertwined. You can't decide a case based on just the conclusion that a claim was a compulsory counterclaim. You have to also look at the elements of res judicata and see if those are present so that denomination as a compulsory counterclaim has any effect. Well, the court in this case found that the claims in this case, all of them, were compulsory counterclaims and should have been brought in a prior case. That prior case is pending, by the way, and it's currently been appealed to the Supreme Court. And then the trial court stated something, I don't mean to pretend I can quote it, but the essence of it is that there was no need to consider the elements of res judicata. On the appeal, what I did in the state court is that the argument that the defendants made was that this was compulsory counterclaims. They mentioned the term res judicata, but they didn't list the elements of res judicata or go into any analysis. I skipped over the compulsory counterclaim argument and took the easier route, I thought, mistakenly, that I would argue that compulsory counterclaim or not, it's not res judicata because the cases you say this claim should have been brought in is still pending. And it didn't satisfy other elements of res judicata, which I went into. Now, some of those elements of res judicata overlap the elements of compulsory counterclaims. Compulsory counterclaims require the same parties, and they require the same transaction or occurrence. Same thing that the compulsory counterclaim definition are also elements of res judicata. So, it's our position that res judicata did not apply for the very simple reason that the prior lawsuit is not completed. It's not entitled, it's not a final judgment. It doesn't satisfy that element of res judicata. Moreover, because some of the elements of res judicata are the elements of what constitutes a compulsory counterclaim or not, involving, in particular, the same parties have to be involved, and the occurrences have to be the same, the transactions have to be the same. I noted these in my brief, and in a nutshell, not all of Tara Colopy's claims in this lawsuit arose out of the same transaction or occurrence as the hospital's claims in the first lawsuit for medical services. These are undisputed facts. There were actually 2 transactions. She went to the hospital 2 different times. Coincidentally, they both cost about $5,000, or at least $5,000 was billed. The first time she paid. And then when she didn't pay the second round, or the second transaction of $5,000, that's what the hospital sued on. She comes to find out that she was overcharged in both transactions. So the first transaction was never a part of this lawsuit for medical fees. Moreover, whereby the class members were the subject of the transaction that is the substance of the hospital's claim for $5,000 worth of medical fees from Colopy. So we feel like, A, the court, in this case, did not, they didn't seek and they didn't receive leave to file a motion for summary judgment right out of the box. I mean, discovery was pending, but hadn't been performed, and you know, the judge, you know, they tried to head that off with a motion for early motion for summary judgment. They didn't seek leave for that. They didn't get leave for that. And then when the court decided it, the court very clearly said, I think this is a compulsory counterclaim, but I don't think I have to talk about res judicata. And for those reasons, I'd ask this court to reverse and remand this case to the trial court for trial. Or in the alternative, if the court were to decide that this truly was, this class action truly was a compulsory counterclaim, then I think the remedy ought to be reverse and render. And the judgment that this court, I would ask this court to render, would be a judgment that would keep from being used against the plaintiffs in appealing the refusal of the first trial court to allow an amendment, allow leave to plead an amendment. And the render would be dismissed without prejudice, or dismissed without prejudice to the right of the plaintiffs to pursue their rights in the first case, which they're doing. That's what's up in front of the Supreme Court now. But the plaintiffs in this case were stuck with an awkward situation. They didn't want that first judgment, that first denial of leave to even plead the class action to be used, to be treated as a final judgment of any kind. That's what spurred the appeal. But because the hospital showed up in the first case and they said, look, Judge, this is so different from anything we're suing for, $5,000 in medical fees, you ought not clog the pipes of the judicial system. You ought to let us just go forward with our $5,000 claim and not let these guys make their counterclaim. And the court agreed, unfortunately, and that's what started this thing. So I continue to try to put my client, get my client a day in court, and if we're in the wrong court for some reason, I don't think we are, but if we are, then the only other court we should be in probably is the first trial court, and I would like to make sure, at a minimum, that this court's summary judgment is changed to a dismissal without prejudice, so that there's no claim in that first court of res judicata.
You were basically wouldn't want an adverse decision from us to be law of the case in the new case.
Correct.
Do we have authority to do what you said?
Oh, I think you do. I think you do. I mean, bottom line is that even if the trial judge was absolutely right, that this is a dead bang compulsory counterclaim, the remedy was wrong. The remedy was wrong. I mean, we shouldn't have a summary judgment that looks like, oh my goodness, this court, you know, undertook a decision on the merits. It didn't. But neither did the first court. I call it a case of race non-judicata. I was trying to get this in front of some court that will look at the merits. I got the impression from the first court that, and from the defendants, that this case is so different than what their case was in the first court, that we ought to be able to just go ahead and file it anew. And that's what we did. Thank you.
Whenever you're ready.
This is Mark Wallach representing Akron Children's Hospital. admit to being a little bit befuddled by some of the arguments the council just made. As far as the issue of whether the decision in this court would affect the first case, I don't see how it could in any case. As this court knows, because this court has previously addressed the untimely appeal that was brought by Ms. Colopy in the first case and has found that it wasn't an appealable order. What's left in that first case is the hospital's initial claim for collection of unpaid medical bills. And ultimately, when that case is resolved and a final decision is rendered, Mr. Hoover is certainly free at that time to come back to this court and raise the question he tried to raise in his earlier appeal of whether the court abused its discretion in denying his client leave to amend for a second time their answer to counterclaim.
To be devil's advocate here,
Sure.
hypothetically, what if that all happened and on that appeal, this court found it in his favor?
Yes. In that case, the court would presumably remand to the trial court with instructions to permit the amendment, and he would be allowed to go forward with the second amended counterclaim at that time. But there's no way in which that would have prejudiced him.
I think what his concern is if there's a ruling in this case upholding the trial court's decision,
Yes.
then there is law out there that says it's a compulsory counterclaim.
Well, there's no question it's a compulsory counterclaim. He's never really opposed that issue. In fact, if you read his brief in this case, he doesn't challenge the issue that it's a compulsory counterclaim. It's identical. The claim here is identical to the claim that was raised in the first case in all except a couple of words. And consequently, it's clearly a compulsory counterclaim. The issue he's raised now in his argument that the class members' claims aren't compulsory counterclaims is really quite irrelevant here, because there aren't any class members' claims until a class is certified. So until a court decides that the requirements for a class action have been met and certify a class, there aren't any other claims in this case other than his client's claim. And nobody else has stepped forward, by the way, and asked to intervene as a plaintiff, and he hasn't raised any alternative claims. So the only claim we're talking about is the claim that's been brought in response to the hospital's suit for medical bills, initially claiming malpractice as a defense, and then when that was unable to be sustained because Mr. Hoover's client was unable to obtain a certificate of merit to bring a medical malpractice claim, they then tried a second amendment and asked to amend the counterclaim to make these new claims of billing irregularities and to call it a class action. So whether that should have been allowed, that's the subject that will eventually make its way up to this court again, I am confident, whenever Mr. Hoover has a chance to do that. But that's not the case that's before us today. The case that's before this court right now is the question of whether it is appropriate and correct to dismiss a case that is identical to a compulsory counterclaim from another case. And the answer is clearly yes. The Ohio Supreme Court has ruled on that multiple times. Mr. Hoover said, well, with respect to compulsory counterclaims, res judicata sometimes applies. Well, that's not really the issue, whether res judicata sometimes applies. As the trial court correctly pointed out, when there's a compulsory counterclaim, you cannot file a second case and bring the claim separately there. And the Ohio Supreme Court, in the Reading Enterprises versus Kohler case, said if both prongs are met, that is, does the claim exist at the time of serving the pleading, and does it arise out of the same transaction or occurrence? If both prongs are met, then the present claim was a compulsory counterclaim in the earlier action and is barred by virtue of Civil Rule 13a. So there's really not a lot of fudge space left in that. It's simply, if it's a compulsory counterclaim in the first case, you can't bring it in a second case.
What about his contention that it's not the same set of events?
Well, now that's really going to his new argument that he made an oral argument for the first time, that it's not really a compulsory counterclaim in the first case. Because the claim in the first case and the second case are identical. There's never been any suggestion that they're different claims. They're word for word the same, other than he becomes plaintiff instead of counterclaim. Other than that, they are word for word identical. So there's no question that it's the same claim. Now the question of whether it was compulsory in the first case, really there's no real dispute about that either, because it arose out of the bills that were submitted by the hospital to his client. Now, he says, well, there were 2 trips to the hospital. Well, that's true. There were 2 trips, and there were more than 1 bill sent. But the question is, was the billing total, the bottom line at the end of the bill that says you owe $5,000 and change that hasn't been paid by your insurance, because the insurance paid most of the claim, but the $5,000 that's left, you haven't paid. Is that the same occurrence that his claim arises out of it? His claim is that the hospital's billing practices are improper. Well, that's the hospital's bill. So there really isn't, if it weren't for that bill that the hospital was suing on, he wouldn't have any basis for a lawsuit because his client didn't have any other transactions with the hospital. So I don't say it's the first time I've heard this argument here at oral argument, but I've never really been able to make any sense out of it. So in essence, I think that this case that's before this court is very straightforward and very simple, which is, can you bring a claim in a separate action, which was a compulsory counterclaim in another action, whatever the status of that other action is? And the answer, I think, is pretty clearly no. Thank you.
Other action, if you look at Rule 13A, counterclaims, or compulsory counterclaim subsection, the other action they're referring to is an other completed action in which there was a final judgment. It doesn't say, because at the end of the day, the concept of compulsory counterclaims is a subset of the law of res judicata. So you can't just say, and counsel continues to say that, if it's a compulsory counterclaim, it's automatically barred. It's barred by the operation, and I've cited the cases that say this, it's barred by the operation of the other concept of res judicata. It's res judicata that bars, not the denomination of type of counterclaim. I will admit that the claims in this case are the same as the claims in the last case. I believe counsel smears the concept of the definition of same transaction or occurrence. He says that he defines a transaction or occurrence from the point of view of my client, being that this hospital is engaged in overbilling and deceptive billing practices. He says, well, that applied to both. But in order to measure whether it's a compulsory counterclaim, you measure the counterclaim against the claims being made by the plaintiff. He's claiming $5,000. That was for a second transaction. My gal's first transaction, she paid for. It took her a while to catch on what was going on. The claims my client is making with regard to her first transaction are not part of the plaintiff's claims for the $5,000. The claims that the appellant is making on behalf of the class is entirely different. It has nothing to do with their $5,000 claim for that second visit. So, whether or not you call it a compulsory counterclaim, and I don't think it is, and I've argued all the facts that lead up to that in my brief, because they overlap. Same parties, same transaction. It's an element of res judicata, it's an element of 13A. Again, I ask the court to reverse and remand, or the alternative, reverse and render, finding that the remedy that the court imposed below was improper and should have been no more than a dismissal without prejudice, so that the first, our ability to prosecute the first lawsuit is not prejudiced. Thank you.
Thank you. All right, gentlemen, thank you both very much. We'll take the matter under advisement, issue a written decision in due course, and it will be mailed to both sides as well as posted on our website, and that the Supreme Court will have.
Thank you very much.
Thank you.